This chapter examines the concept of justice and its relationship to the law. As you'll discover, the determination of what is truly just is a very subjective matter. Our goals for this chapter, then, are first, master a conceptual understanding of justice, distinguishing it from the concept of law. 2, apply two different perspectives on justice offered by Aristotle and Karl Marx. 3, recognize the way that justice becomes a part of law. 4, explain the relationship between the rule of law and due process, their historical origin, and their incorporation into American law. 5, describe and evaluate Herbert Packer's two models of America's criminal justice system. 6, understand and apply the following concepts: distributive justice, retributive justice, relevant differences, proportional deterrent effect, legal realism, mala in se, mala prohibita, rule of law, and due process. In the past, when I've taught this class face-to-face with students, I've asked them to give me their personal definition of justice. And every semester, the answers are much the same. Justice means fairness, equality, or just getting what you deserve. But those definitions just beg other questions. What is fair? What is equal? And how do you determine what someone truly deserves? Before we get any further toward answering those questions, let's recognize that there are two different contexts in which justice is sought. Distributive justice, which is about how we distribute our limited resources, and retributive justice, which is more about punishment, how we will punish bad behavior. Punishment should fit the crime, right? Punishment should be fair. So justice then regulates how we distribute our limited resources, such as money, property, food, or water, and how we behave towards one another. For purposes of this class, we're going to focus on two different theories of what justice looks like: Aristotle's theory and Marx's theory. Their two ideas reflect two competing notions of justice in Western European society. Aristotle says that justice means treating equals equally and treating unequals unequally according to relevant differences. Karl Marx says that justice is taking from each according to his ability and giving to each according to his need. To understand them better, let's apply each theorist's idea to specific situations. I'm borrowing from the textbook on these if you want to refer to pages 31 and 32 of the textbook as we go along. And keep in mind that these examples are just meant to teach a concept and they are not necessarily realistic. You'll also want to keep in mind the historical context of these two people. Remember, Aristotle was working well back before the birth of Christ, and Karl Marx was in the 1800s, so relatively recently after the Industrial Revolution, after public education became mainstream. So the first question is related to grades. Suppose I am grading your final exams for this course. Each exam is worth 100 points, and there are 10 students in my class, which would give me a potential total of 1,000 points to distribute to the class in the form of test scores. Suppose that the points actually earned by the students collectively amount to only 800 points. So that means not every student earned a perfect score of 100 points. Some got far fewer questions correct, and their personal score was much lower than 100. What is the just distribution of the 800 points that our class earned on the final exam? Now, if justice simply means equality, then each of the 10 students in my class would receive an 80 on the exam, regardless of how they personally performed on the exam, and regardless of how many questions they got right, and regardless of how hard they worked to learn the material. Is that truly just? What do you think? What would Marx say? Well, Marx considers ability and need in his view of justice. He would look at the individual student to see how many points each student needed to receive. Say you are a student who earned only 60 points on your exam, and if I gave you that score of 60, your overall GPA would drop below the threshold for you to keep your scholarship. You need 90 points to maintain the 3.0 GPA to keep your scholarship and stay in college. Marx would say that it is just to give you those 90 points simply because you needed it. Marx would say it is just for the more capable students to give up the points they earned and give them to you. If the other students in the class have greater ability to earn more points for the collective whole class, then it is just for them to do so, even if that means the points they were able to earn are given to a less capable student. What do you think? Is that truly just? Now, what would Aristotle say? Aristotle considers relevant differences in his view of justice. What would those relevant differences be in this example? The answer is the contribution of the individual. If the individual student contributed more intelligence and effort to the learning of the material and got more questions correct, then that student receives more points from the pot. So giving an unequal amount of points to some students is therefore just. A student receives the amount of points that his or her talent and effort earns them, even if that means that other students receive far fewer points and lose their scholarships. Is that just? Here's another example. Something a little closer to reality. Our next example relates to more basic needs: food, clothing, and shelter. Is it just for a person to receive money generated by tax revenue in order to buy food for themselves? I'm talking about our national welfare system, you see. The money that individuals pay in taxes goes into a pot that the government then redistributes to various programs, including SNAP, the Supplemental Nutrition Assistance Program. It is given in the form of a card, like a debit card, that low-income earners can use at grocery stores to buy food. So it is not money that the poor person ever actually earned by their labor. It comes from money that other people earned and paid to the government in taxes. Is it just to give poor people SNAP cards? Well, if justice simply means equality, then all the money that everyone in our country earned would be put into a collective pot and then be divided up equally and given in equal shares to every citizen of our country. Is that truly just? What would Marx say? Marx would say that SNAP is just. People give up their money in accordance with their ability to do so, and people receive money in accordance with their need for it. If you are able to earn more money than you need to buy yourself food, then you must give it to another person who needs it and cannot earn it for themselves. People need to eat to live. Therefore, it is just to give them money for food. Is that truly just? What would Aristotle say? Aristotle would consider the relevant differences among people. The relevant difference is what a person contributes to society. A person receives what they earn. Resources are distributed in proportion to his or her contribution to society. If a person contributes nothing, he or she receives nothing, even if it means that person will starve to death. But if a person's poverty is due to circumstances beyond his or her control, then Aristotle would see it as just to give him or her some of the resources. The factors that caused the person's inability to earn are relevant differences that might justify the disproportionate distribution of food benefits. Aristotle would condemn the exploitation of laborers just as he would condemn the exploitation of the welfare system. His theory is seen both in our government's regulation of business and in our progressive income tax. Do you agree that this is truly just? Now let's consider retributive justice, or punishment. Remember, retributive justice is about punishment. If we asked Marx how he would define retributive justice, he would likely discuss the exploitation of the ruled class by the wealthy. Remember that he is the founder of the conflict theory. So we're just going to focus on Aristotle then. Aristotle, as with distributive justice, would consider relevant differences in the exactment of punishment. If I asked you what factor should determine the punishment for a crime, I bet you would first look to the severity of the crime. Murder, for example, receives a harsher punishment than shoplifting. But is the severity of the crime the only relevant difference? What about differences among the offenders? Many jurisdictions consider whether the offender has committed crimes before, whether the offender is a juvenile, whether the offender has a mental illness, and so on. Many jurisdictions have sentencing guidelines that require judge or jury to consider many factors before delivering a sentence. Those factors are the relevant differences that might justify a different sentence, even for the same offense. Now, consider this for a moment. We punish people to deter them from committing the same crime again. We are creating, with our criminal justice system, disincentives for criminal behavior. If a person knows that he or she will for certain be caught and imprisoned for a crime, that person is less likely to commit the crime because he or she has been effectively deterred from doing so. Punishment is meant to be painful, unwelcome, so that it can be a deterrent. But what if punishment isn't really painful? So take this scenario I have on the slide as an example. Say a cardiologist and a janitor are driving home from work on Highway 25 in Greenwood. Both are decent men, tired from having worked a long 10-hour day, and both do not notice that he is speeding, going 65 miles per hour in a 45-mile-per-hour zone. Both men are caught at the same place on Highway 25 at the same time and under the same road conditions. Should each man be fined the same amount of money? If I didn't point this out, the men are driving separately in separate cars. They're not riding together. So they're both driving their own car when they get pulled over. So should each man, the cardiologist and the janitor, be fined the same amount of money, meaning their ticket? Should it be the same fine amount? If the cardiologist, and most cardiologists are somewhat wealthy, if the cardiologist earns $10,000 a month and the fine is $100, would he even notice that $100? It's only 1/100th of his monthly income. He might spend that sum of money on a single meal without batting an eye. But to a janitor who earns, say, $1,000 per month, that $100 fine is painful. That's a week of groceries he can't buy because he had to pay a fine. It's 1/10 of his income. So the proportion of each offender's income is different. One proportion is more painful than the other. So is imposing the same fine still just? A few jurisdictions consider the offender's income status as a relevant difference and impose fines in proportion to the offender's income so that the deterrent effect of the punishment is equal. Is that just? What do you think of proportional deterrent effect? Take a moment, think about that. Now, just to recap before we go further, what is justice? Justice is an ideal that relates to how we distribute resources, so distributive justice, and how we treat each other, retributive justice. It is applied in the context of the distribution of resources and the punishment of offenses. Aristotle's conception of justice considers relevant differences among individuals and situations that might justify the unequal distribution of resources and the unequal application of punishment. Marx's conception of justice considers only ability and need. He is the proponent of conflict theory. Aristotle's conception of justice is more like our system of distributive and retributive justice in America than Karl Marx's. Our government regulates businesses in order to deter and prosecute the exploitation of laborers, consumers, and the environment. Our government redistributes wealth so that those who cannot work have their basic needs met, and does so in a way that is meant to prevent the exploitation of that system of welfare. But Aristotle's conception of justice and America's system of wealth distribution and criminal justice are far from perfect. There are many flaws in the system. Think for a minute. Who decides what a relevant difference is when it comes to the distribution of resources or the imposition of punishment? Judges, juries, political leaders. In other words, human beings decide, and humans are flawed. Racism, sexism, all the isms are at work, even if only subconsciously, in the psyche of each human being. Humans are self-interested and do not always work for the benefit of the common good. Bias, stereotypes, political pressure, a desire for re-election, money, they all affect human choices. That is why outcomes are different. An idealistic person might think that judges simply apply the law to the facts of the case and decide the case uninfluenced by their own subjective beliefs about what the outcome should be. But that, I assure you, is not the reality. That is the subject of study in legal realism. Legal realism is the study of how law is actually applied in the court systems day to day, how both internal and external factors other than the law affect the outcome of a case. Legal realists believe that case outcomes are influenced by much more than just the law. And keep that in mind as we move on to consider the relationship between justice and law. Just as we spent a good bit of time with Chapter 1 in the examination of where our notion of law comes from, let's think about where our notion of justice comes from. Looking at this picture, you might recognize a familiar time in your life. Have you ever felt jealous like this child clearly does? You can just hear her cry, "That's not fair." It seems that humans are born with the ability to recognize when something is not fair. Does that mean that humans have an innate sense of justice? Well, there are two perspectives on that question. Some people adhere to the idea that justice comes from an external source, and that source is a timeless, universal source, and it is disconnected from humanity. If you are a religious person, you might equate that source with God, but it isn't necessarily true. Either way, the idea is called transcendental natural law. It is akin to the natural law theory of the philosophers we studied in Chapter 1, such as Plato's theory of forms. Justice comes down from some transcendental realm, and humans discover it through education and intellectual exercise, or if you were religious, you would see it coming from a spiritual exercise. As we discover it, we modify our laws to match our discovery and thereby make our laws more just. In this perspective, laws deemed unjust are not and never were valid law. We can therefore punish unjust actions, even if those actions were legal at the time they were performed. You might recall Chapter 1's discussion of the Nuremberg trials as an example of transcendental natural law theory. Under that theory, it was absolutely just to prosecute Nazis for crimes against humanity, even though the law of Germany sanctioned the sickening slaughter of Jews at the time and in that country. Transcendental theory was adopted by most of our nation's founders and made its way into our federal government. The founders believed that British laws were unjust and that they were justified by nature's God. So here you see the transcendental realm as the source of justice, justifying their choice to defy British rule and form their own country. A different perspective on the source of justice is known as the evolutionary perspective. This is the idea that justice is something realized, not discovered. As humans evolve, they come to realize which behaviors promote their survival. Those behaviors are therefore just, and they become the norms of society and ultimately the laws that are written down in the law books. So justice then is not transcendent. It does not exist separate from humanity. It exists because of humanity. It is realized in the form of moral outrage. We feel from inside us a sense of disgust for behaviors that harm or kill us. So we condemn those behaviors and make laws that prohibit them. Evolution, however, is affected by our environment. So behaviors that are condemned by one culture may not be condemned by another. That is why laws may be different depending upon one's location and time period. A man named Raphael Garofalo categorized these behaviors in order to demonstrate the point. Some behavior is universally condemned across time and space in every culture and at every time in history. They are known as natural crimes or mala in se crimes. They are bad in and of themselves. Murder, rape, theft are among them. It is easy to see how Garofalo's theory of natural crime goes along with the evolutionary perspective of justice, because those natural crimes, if left unpunished and undeterred, would lead to the exploitation and destruction of humanity. Murder certainly does not lead to the survival of the human race, quite the opposite. Humans naturally feel outraged if they witness rape or theft and feel a desire to retaliate and punish that exploitation. Other behaviors, though, are not universally outrageous and condemned. According to Garofalo, they are not really crimes. They are just behaviors that are deemed bad by the specific culture or jurisdiction at a specific time and then punished. They are known as mala prohibita. An example might be gambling or prostitution. So if justice is discovered or realized, what next? How does that sense of justice become part of our culture? Well, law is the answer to that question. Society conforms its laws to match its sense of justice. Law becomes the mechanism by which justice is achieved. Here are two ways that occurred in Western European culture. The first way is through the application of equity in the justice system. Recall Weber's decision-making typologies. One of them is formal, rational decision-making, where legal precedent is applied to a set of given facts by a disinterested legal expert, and a predictable outcome is reached. What if that application of legal precedent results in an injustice? How does the judge rule fairly? He or she must apply equitable principles or equity. By doing so, doing so takes away from the predictability of the justice system, because it allows a judge to apply substantive decision-making, case-by-case rulings that vary. Many years ago, a separate system of courts developed that operated parallel to the common law court system in medieval Europe. When a judge, back in medieval Europe, applied the ancient principles of common law, and it resulted in an unfair outcome, the petitioner would go to the king's chancellor and ask for equity. A chancellor is sort of like a chief of staff for a king. The king's chancellor had the power to change the ruling of common law in order to achieve a fair and equitable result. Well, over time, An entirely separate system of dispute resolution was established to deal with situations that the common law simply could not settle fairly. It was known as the Chancery Court, from the title chancellor. Judges in the Chancery courts were trained to be flexible and fair in their outcome at the sacrifice of predictability. You see in the slide a picture of Westminster Hall. That's one of the oldest known Chancery courts in Western Europe. Well, ultimately, these two systems, the common law system and the equity system, they cross-pollinated, meaning they borrowed from each other, and both began to improve itself by the influence of the other. Common law courts became more flexible, and equity courts became more predictable. Eventually, most states saw the two systems merged into one. For example, in our federal court system, the judge can be asked to apply law or equity, depending upon the circumstances. But some states still have a dual system, with equity or chancery courts tending to handle family law matters almost exclusively, such as divorce, adoption, and juvenile delinquency. But in most jurisdictions, principles of equity are simply applied by judges at law, and those equitable principles then become the legal precedent for future cases. Hence, the equity, or justice, becomes the law. This case, Riggs versus Palmer, is a real-life example of how equity merged into common law, and it's a pretty colorful story. There was and is a principle of law that requires written wills to be enforced regardless of extraneous evidence as to the decedent's wishes. The decedent is the person who died. That law applied to the will of Francis Palmer, who died a very wealthy man. Francis Palmer died with 3 potential heirs, his 2 daughters and his grandson Elmer. Under Francis Palmer's written will, his grandson Elmer stood to inherit the entire fortune. But it was found by a criminal court that Elmer killed Francis. This grandson, the heir to the fortune, poisoned Francis so that he would not have the opportunity to change his will before he died. Elmer was tried, convicted, and sent to prison for murder. So what is the court to do with that vast estate? Well, under the law, Elmer must receive it. That's what the written will said. But that was certainly an unjust result. So the daughters petitioned the court to apply equity. And a majority now, not all of them, a majority of them agreed. The court threw out the will and gave the inheritance to the daughters instead of the murdering grandson. But that decision had dissenting justices, and it prompted an outcry. The court had defied a long-established legal precedent that afforded much desired predictability to the passage of wealth from generation to generation in accordance with the will of the decedent. But it was the equitable thing to do. And following this decision, the legislature enacted a law that now every state has, known as a slayer statute. You cannot inherit the wealth of the person you murder, even if you are the heir under the written will. So there's an example of how equity became law. The merging of equity and law was only one way that justice worked its way into our legal system. There was another way too, through the Enlightenment period. For centuries of time, Europe was ruled by kings, and the king was the law. Indeed, cultures believed that the king was endowed by God with the authority to rule, and therefore the king's rule was divinely ordained and supreme. In this slide, there is a picture of a lettre de cachet, and I know I'm pronouncing that wrong. It's a sealed letter that in France would permit the holder of the letter to seize a person and his property without notice or explanation and imprison them for an indefinite period of time with no right to a lawyer or to confront his accusers. It is a gross example of the abuses of kings who were deemed above the law. The king could give a loyal nobleman the right to destroy another person's life with no accountability at all. But that did not last forever, thankfully. We'll learn more about it in chapter 3, but over time, powerful people began to assert the supremacy of law over man, law over king, the rule of law. Over time, elected representatives to Parliament and their scholars deemed certain matters beyond the whim of the king. They were rights that humans were simply due because they were human. It began with the Magna Carta signed by King John in 1215, and through great bloodshed came to become part of the English system of government. In the 1600s, a man named Sir Edward Coke. I'm mispronouncing that. It happens often. It looks like Coke, the drink, but it is Cook, Sir Edward Coke. In the 1600s, Sir Edward Coke outlined these rights and called them due process, procedures that must be followed before any human could be deprived of his life, liberty, or property. Subsequent scholars expanded on those ideas, including Cesare Beccaria, an Italian nobleman and law professor. He argued that persons charged with a crime were due the right to confront the witnesses against them, to know the charges against them, and to have a speedy trial before an unbiased judge. Beccaria even advocated the abolition of the death penalty. He wrote that punishments should be proportionate to the harm caused by the offender, and that they should be applied consistently to all those convicted of the same crime. Does this sound familiar? It should. The due process rights that Beccaria and Coke advocated became the rights guaranteed by our Constitution. Their writings and those of other Enlightenment scholars influenced the founders of our country and the people who wrote our Constitution. In order for this enlightened sense of justice to be seen as legitimate, we needed a constitution to entrench those just principles. Our American culture recognized the supremacy of law over man and made that the very fabric of our society through the U.S. Constitution, and held our justice system accountable for the protection of due process rights. Now compare King Louis's lettre de cachet to our modern day arrest warrant. Under a lettre de cachet, the authorizing document is a sealed letter and is issued at the whim of a king. But today, in a modern arrest warrant, the authorizing document is a matter of public record, and it requires probable cause. Back then, in a lettre de cachet, the subject who is imprisoned is imprisoned indefinitely. But today, with an arrest warrant, the subject has a right to a speedy trial. Back then, the subject never knew his or her accusers. Now, subjects have a right to cross-examine and confront witnesses. Back then, the subject may never see a judge, but now the subject has a right to a disinterested judge and jury. It is easy to see through this comparison that we have come pretty far with the entrenchment of due process in our justice system. But would you say that generally our criminal justice system is just? I'd wager that many of you could list several problems with it. Especially this past year, we've heard a good bit about the way our criminal justice system does not protect the due process rights equally and consistently. We should and will continue to change and adapt our laws so that they get closer to the ideal of justice. This last slide shows a way of analyzing our modern criminal justice system. It was developed in the 1960s by a professor named Herbert Packer. He proposed two models of the criminal justice system. One, the crime control model, and the other, the due process model. These models are not meant to fully describe our justice system independent of one another. Rather, they show the two ends of a continuum, or opposite sides of a pendulum, perhaps. If you believe that safety and security is more important, then you might wish our criminal justice system better fit the crime control model. You might be more comfortable with the risk that a factually innocent person might be imprisoned than with a factually guilty person going free. You would have great faith in the criminal justice system and believe that justice is usually served in the end, even if some rights are compromised along the way. On the other hand, if you believe that the integrity of the justice system is more important, you might wish our criminal justice system better fit the due process model. You would be more comfortable with the prospect of a factually guilty person avoiding punishment than a factually innocent person being imprisoned. You would take pride in the fact that there are obstacles for prosecutors to overcome before liberty is taken away. Your preference between these two models, crime control or due process, is likely a reflection of your values. And remember, we learned in Chapter 1, our values are intertwined with the law and the justice that it seeks to achieve. That's the end of this lecture. Please proceed now to take the quiz and do your other assignments.